Imagine a world where your entire life, your memories, your finances, your passions, and even your identity exists in the digital realm. From your social media profiles and cryptocurrency wallets to your treasured photos and digital businesses, your digital life holds immense value. But here's the million-dollar question. What happens to all these digital assets when you're no longer here to manage them? In this video, we dive deep into the critical legal frameworks you need to know to protect, preserve, and pass on your digital legacy. Think of it as building a digital safety net for your loved ones, making sure your online wealth, memories, and presence don't vanish into cyberspace. Whether it's navigating complex privacy laws, understanding property rights for your digital treasures, or making sense of platform terms of service, we've got you covered. Your digital footprint is part of your legacy, a powerful, lasting connection to future generations. Don't let confusion or inaction leave your digital assets lost or unprotected. Join us as we explore how to legally secure your digital world and ensure your story lives on. Let's get started and take control of your digital destiny. Overview of relevant laws and regulations governing digital assets. Digital assets are a relatively new form of property that has emerged with the advent of the internet and the widespread use of technology. With the increasing value and significance of digital assets, it has become necessary to understand the laws and regulations that govern these assets to ensure proper estate planning. 1. Property laws. Digital assets, such as cryptocurrencies, digital media, and online accounts, are considered property under the law. Property laws govern the ownership, transfer, and inheritance of digital assets, just like any other form of property. It is essential to identify and categorize different types of digital assets to determine how they will be treated under property laws. 2. Privacy laws. Privacy laws play a crucial role in governing digital assets, especially when it comes to access and disclosure of online accounts after death. Many online service providers have specific terms of service agreements that dictate what happens to an account in the event of the user's death. Understanding these privacy laws and terms of service agreements is essential for estate planning involving digital assets. 3. Digital estate planning laws. Some jurisdictions have started enacting specific laws that address digital estate planning, including the management and transfer of digital assets after death. These laws may provide guidance on how to access and distribute digital assets, as well as designate digital executors to manage online accounts and assets. 4. Tax laws. Tax laws also play a role in governing digital assets, especially in terms of inheritance and capital gains taxes. The value of digital assets and any income generated from them may be subject to taxation, so it is essential to consider the tax implications when planning for the transfer of digital assets to beneficiaries. 5. Cybersecurity laws. Cybersecurity laws are another important aspect of governing digital assets, particularly in terms of protecting digital assets from unauthorized access or theft. Understanding cybersecurity laws and best practices for securing digital assets can help prevent loss or misuse of these assets. Overall, navigating the complex legal landscape surrounding digital assets requires a thorough understanding of the relevant laws and regulations. Estate planning for digital assets should take into account property laws, privacy laws, digital estate planning laws, tax laws, and cybersecurity laws to ensure that digital assets are properly managed and transferred according to the individual's wishes. Working with legal professionals who specialize in digital asset planning can help ensure that all legal requirements are met and that digital assets are appropriately protected and distributed. Understanding the terms of service agreements for different platforms. Understanding the terms of service agreements for different platforms is a crucial aspect of managing digital assets as part of estate planning. These agreements outline the rules, rights, and responsibilities that users must adhere to when utilizing online services and platforms. When it comes to digital assets, such agreements can have significant implications for how these assets are handled after the user's death. 1. Reviewing terms of service agreements. It is essential to carefully review the terms of service agreements for all the platforms where you have digital assets stored. These agreements can vary widely in terms of their provisions related to access, ownership, and transfer of digital assets upon the user's death. 2. Access and ownership. Some terms of service agreements may specify that users do not actually own the digital assets stored on the platform, but rather have a limited license to use them. In such cases, it is important to understand what rights, if any, can be transferred to heirs or beneficiaries after the user's death. 3. Transferability and inheritance. Certain platforms may have specific provisions regarding the transfer of digital assets to heirs or beneficiaries. For example, some platforms may allow users to designate a successor or provide instructions for transferring account access upon death. Understanding these provisions is crucial for ensuring that your digital assets are properly accounted for in your estate plan. 4. Digital asset inventory. As part of estate planning, it is advisable to create an inventory of all your digital assets, including a list of the platforms where they are stored and relevant login information. This inventory can help your executor or loved ones navigate the terms of service agreements and access your digital assets in accordance with your wishes. 5. Seek legal advice. Given the complex and evolving nature of digital assets, it is recommended to seek legal advice when drafting your estate plan. An attorney with expertise in digital estate planning can provide guidance on how to navigate terms of service agreements, ensure compliance with relevant laws, and protect your digital assets for future generations. Understanding the terms of service agreements for different platforms is a critical step in estate planning for digital assets. By carefully reviewing these agreements, documenting your digital assets, and seeking professional guidance, you can ensure that your digital legacy is preserved and passed on responsibly. Estate planning considerations for digital assets. In the modern digital age, it has become increasingly important to consider how to handle digital assets as part of your estate planning. Digital assets can include a wide range of items such as online accounts, social media profiles, cryptocurrency, digital photos, music libraries, and more. Here are some important considerations to keep in mind when planning for your digital assets in your estate. Inventory and documentation. The first step in estate planning for digital assets is to take inventory of all your digital assets. This includes creating a comprehensive list of your online accounts, passwords, and any important digital files or assets. It is essential to keep this information up to date and stored securely. Consider using a password manager or secure digital vault to store this sensitive information. 2. Digital estate plan. Just like you have a traditional will that outlines how you want your physical assets to be distributed after your passing, you should also create a digital estate plan. This plan should clearly outline how you want your digital assets to be managed and distributed. Be sure to include instructions on how to access your online accounts and any wishes you have regarding the handling of your digital presence. 3. Appointing a digital executor. Consider appointing a digital executor in your estate plan. This individual will be responsible for managing and distributing your digital assets according to your wishes. Make sure your digital executor is someone you trust and who is familiar with technology and online accounts. 4. Privacy and security. When planning for your digital assets, it is crucial to consider the privacy and security implications. Include instructions on how you want your personal information to be handled, especially for sensitive accounts like banking or cryptocurrency accounts. You may also want to specify how you want your social media profiles to be managed after your passing. 5. Legal considerations. Different jurisdictions may have varying laws and regulations regarding digital assets. It is essential to consult with legal professionals who are knowledgeable about digital estate planning to ensure that your wishes are legally enforceable. Be sure to update your estate plan regularly to account for any changes in laws or technology. Estate planning for digital assets is a crucial aspect of modern estate planning. By carefully considering and documenting your digital assets, you can ensure that your online presence is managed according to your wishes after your passing. Be proactive in addressing these considerations to protect your digital legacy and simplify the handling of your digital assets for your loved ones. Working with legal professionals to draft digital asset-specific documents. Working with legal professionals to draft digital asset-specific documents is a critical step in ensuring that your digital assets are properly accounted for and managed in your estate plan. These documents serve to outline your wishes regarding the distribution and management of your digital assets upon your incapacity or death. Here is a detailed section on this topic. When it comes to estate planning for digital assets, one of the key aspects is working closely with legal professionals to draft digital asset-specific documents. These documents are essential in ensuring that your digital assets are properly accounted for and handled according to your wishes. 1. Identifying digital assets. The first step in drafting digital asset-specific documents is to identify all your digital assets. This includes but is not limited to online accounts, social media profiles, cryptocurrencies, digital files, and any other valuable digital property you may possess. 2. Understanding legal implications. Legal professionals specializing in estate planning for digital assets can help you understand the legal implications and complexities involved in managing these assets. They can guide you on how to include digital assets in your estate plan in compliance with relevant laws and regulations. 3. Drafting digital asset inventory. As part of the process, legal professionals can assist you in creating a comprehensive inventory of your digital assets. This inventory should include detailed information about each asset, such as account usernames, passwords, account numbers, and any specific instructions for their management or distribution. 4. Creating digital asset-specific documents. Legal professionals can help you draft specific legal documents that address the management and distribution of your digital assets. These documents may include a digital asset will, a digital power of attorney, and digital asset trust documents, among others. 5. Specifying digital asset executors and trustees. In these documents, you can designate individuals or entities to act as executors or trustees for your digital assets. These individuals will be responsible for carrying out your wishes regarding the management and distribution of your digital assets after your passing. 6. Updating and reviewing documents. It is crucial to regularly update and review your digital asset-specific documents to ensure that they accurately reflect your current wishes and asset holdings. Legal professionals can assist you in making any necessary revisions to these documents over time. 7. Ensuring security and privacy. Legal professionals can also advise you on how to ensure the security and privacy of your digital assets during your lifetime and after your passing. This may involve implementing cybersecurity measures and encryption protocols to protect sensitive information. Working with legal professionals to draft digital asset-specific documents is essential for comprehensive estate planning that includes your digital assets. By seeking professional guidance and expertise in this area, you can ensure that your digital assets are properly accounted for and managed in accordance with your wishes and the law. Your digital life is more than just a collection of accounts, passwords, and files. It's your story, your hard work, your passions, your memories, and your legacy. In a world where so much of who we are now lives online, ensuring that your digital assets are protected and passed on according to your wishes is not just practical, it's profoundly personal. Imagine the comfort of knowing your loved ones will have access to your cherished memories, the financial security you built, or the businesses you've grown. Think about the peace of mind you'll feel knowing that your story won't be lost in a forgotten inbox or inaccessible cloud drive, but instead preserved and passed on like a treasured family heirloom. The laws and regulations may be complex, but with understanding, planning, and the right legal guidance, you can secure your digital legacy with confidence. Your digital world deserves the same thoughtful care as your physical one. Because every email, every cryptocurrency investment, every photo, and every idea you've shared online matters. Don't leave your digital footprint to fade into obscurity. Instead, leave a legacy that reflects your life, your values, and your love for those who matter most. Take control, make a plan, and give your digital assets the future they deserve. Your story is worth protecting. Your legacy is worth preserving. Start today, because the digital world you've created deserves to last forever.